Good morning. Are you Michaelan Skinner? Speak up, please. And Mr. Rennick, will your client waive the formal reading of the indictment?
He will.
Give me just a second to get that pulled up. Mr. Skinner, in cause number 25 DCCR 1852, you're charged with the third-degree felony offense of theft of property from November 6th of 2025. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I need you to speak up because I can't hear you and this lady over here has to hear you. Okay, so use your big voice. Use your outside voice instead of your inside voice, okay? Okay, so I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rennick? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 5-year deferred probation. There would be a $1,000 fine, and there would be restitution determined, if any, between now and when we come back for sentencing. And if there is any restitution, you would be required to pay that. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Skinner is not competent?
Not for those tests.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today to start that process, and she's sitting at that desk right over there. Okay? We'll see you back at sentencing. Thank you.
Thank you, Your Honor.
Thank you. Ms. Hawkins, are you ready on, let's see, Mr. Spites? Okay. Oh, well. All right, again, you're Devin Spites. And so now that everybody's had an opportunity to visit about the pre-sentence report, Ms. Hawkins, is there anything? Anything you want to add? Sorry. That was
I spoke to Mr. Spice outside. He informed me that he was nervous in his interview, but he is taking full responsibility for what he has pled to with that, and he has advised me that he understands that he is guilty.
Okay.
He doesn't really know why he said that other than just nervous.
okay.
As far as the recommendations, Your Honor, the recommendations do include ISF. Judge, Mr. Spites he's not from Jefferson County. He doesn't live in Jefferson County. He does not frequent Jefferson County. And I do want to bring to the court's attention, the only reason we are before you in this court is because the penal code does allow jurisdiction in the counties where a person has stolen goods. So he was pulled over going down I-10, passing through Jefferson County. I think that's important because what his actions did was they did not affect the people of Jefferson County in a direct way. And I think that's something that should be considered when placing someone on community supervision in the community where they are charged with a crime. I think it's important that his actions did not occur in Jefferson County in this case. He has a delicate situation right now, Judge. He has 5 children who are very, very small. I think 3 of them are babies, they're still infants. Additionally, as the PSR shows, he has pending cases in Fort Bend right now. He's going to court on those cases. He's dealing with those. I think having him in ISF is going to create much more of a stressful situation for him in providing for his children and dealing with those cases and resolving everything he has going on than it would to help him. And I think the point of community supervision is to help the people who enter into it He's willing to do all the other conditions of community supervision, the drug testing and all that. I think that if ISF was recommended partially because of him admitting to marijuana use. He's willing to.
If I test you this morning, you gonna have it in your system? Have a seat in the jury box. Let's check you. Then we'll go forward.
Just Mr. Spice has a form that he will test positive.
Okay, let's get it done just to make sure. Thank you, though.
Yes, ma'am.
I appreciate him. That way I have something in my file as well.
Yes, ma'am.
Mr. Ward, you have Bart Thibodeau,
Yes, ma'am.
2 cases.
Yes, ma'am. Good morning.
Good morning, sir.
How are you?
Good, how are you doing?
Traffic was a little. Yeah.
Where are you coming in from?
I actually fall short. So the other side of Keystone.
Oh,
So the
okay,
west
so you got
gate.
the both sides.
Mm-hmm. Super exciting. I was at 6:30 this morning. So.
Oh, wow.
Yeah. Super fun.
Good morning, sir. You're Bart Thibodeau?
Yes, ma'am.
And Mr. Thibodeau is here in cause number 25 DCCR 0339, charged with solicitation of prostitution, and 25 DCCR 0755, charged with possession of a controlled substance. And what is the announcement?
Plead not guilty to both counts.
And let's see, when were you, I'm trying to see
January 8th, I believe.
when you were hired. I don't even see it in this file.
Did the motion? Did I have it? 'Cause I got most of the discovery.
No, I'm sure you did, but otherwise I wouldn't have you on my docket. I just don't see when it was filed. So what I'll do, Mr. Thibodeau, is reset the cases for about 30 days to give you some time, get with Ms. Malfino. She'll explain the process to get on the portal, to get all the discovery, and then we'll see where we are at that next court date.
Okay, perfect.
All right, make sure you stay in touch with Mr. Ward. He's going to get all the discovery in the case electronically, and then he will, I'm sure, want to get with you and go over all of that before the next court date. All right, you're free to go. Thank
I
you.
would go with this. As far as he did want to amend some bond conditions, I don't know if you guys wanted a formal.
Did you file a
No, I
motion on
didn't. I
that?
just wanted to see if you wanted to do a docket entry or would you like me to file a formal?
I think just to give Ms. Malfino time to see what that is, if y'all want to talk about it real quick before you leave, if there's some agreement, you can let me know. Otherwise, if there's some issue, I'll give her at least a week or so to get ready on that.
I
All right,
completely understand.
just let me know.
Minutes so
I'll
that
hold
He
it.
doesn't have to come back.
Yes, sir. I'll hold it, ma'am. And have we seen Mr. Sean Villery, Samuel? Oh. There it is. Well, he got out to come in to see us. That's not fair. It's very old. Gotcha. Oh, yeah,
We're all ready on Courtroom.
okay.
His dad is gonna be up here for the plea. As you know, his dad's been appointed as guardian.
Sure, that's fine.
I feel like he's more than competent to take the plea and everything else, but I just want to cover my
We'll put all
behind.
that on when it's time to.
Okay, I'm just letting you know, so I'm not scaring you while
Thank
you
you.
come up here.
Thank you.
So,
Mr. Stringfellow on John Roy. And do you have your discovery certification? Okay, perfect, thanks. Thank you, Mr. Coleman. Thank you, sir.
I need to email that.
Good morning, sir. Are you John Roy?
Yes, ma'am.
And Mr. Stringfellow, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Roy, in cause number 25, DCCR 1365, you're charged with a state jail felony offense of driving while intoxicated with a child under 15, and that's from July 3rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Stringfellow? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated for 4 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1, Mr. Stringfellow.
Yes, no objections.
It's admitted. Is there any evidence that Mr. Roy is not competent? All right, Mr. Roy, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a precedence report.
Couple of things, Judge. The agreement contemplated an interlock device. I don't know if we put that in the paperwork. And another thing, Judge, I don't know if the court would entertain, Mr. Stringfield and I talked about this, maybe waiving if he decides this.
Okay, let me, can you send me that paperwork back, Anna, and I'll write, that's your agreement, is that he would have an auto ignition interlock device on any vehicle he drove?
Yes, sir.
No history that you
Judge,
can,
the state's file reflects a 1994 operating a vehicle by intoxication. That's out of the state of Louisiana. And a couple of arrests, an arrest for battery in 2008, another arrest for battery in 2019. Other than that, no other criminal history. My understanding is that the defendant is from Louisiana.
Yes, he resides in Louisiana.
okay. So, with everyone's permission first, can I make that right in on that agreed punishment recommendation page, the agreement for the auto ignition interlock device?
No objections.
No objections.
All right. So then what I'm going to do, Mr. Roy, based on Mr. Coleman's representations with regard to any real lack of criminal history, is waive the pre-sentence report. So again, make that finding that you entered that plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of the state jail felony offense of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that, so you're on probation for 4 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes having the auto ignition interlock device on any vehicle that you drive. You cannot drive a vehicle unless it has that. You'll talk to probation today here in the courtroom. She'll probably send you over to the probation office at some point. It's important you give them all the information of where you live so that they can work on the proper process of getting your probation transferred over where you are, okay? I'm handing you now the trial court certification. That shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney, all right? Good luck to you, sir. Make sure you stop and talk to probation. She might be ready for you now. She might have you have a seat and then visit with you. Yes, sir.
He currently has a portable device. Do you think it's possible for him to keep that device instead of installing the permanent machine into his vehicle?
Mr. Coleman, what's the state's position with regard to the portable?
Not necessarily opposed to that, Judge.
Is it it's not required on the state jail felony for him to have, for me to make a finding on the auto ignition interlock. It's not. Okay, so what I will do is have probation place, if he has the portable, he doesn't have to have the auto ignition. If there's any issues at all with missing portable, if you miss blowing or it's whatever happens with that, number one, it could be a violation of your probation, or it could require maybe having both, or whatever it's gonna take for me to feel like you're safe out there on the road. But keep doing the portable for now. I'll take away that interlock requirement unless there's some issue that comes up that makes me feel like that would be necessary.
Thank you.
All right, yes, sir. So stop and talk to probation. She'll let you know you probably need to have a seat after that for a few minutes. All right,
Thank you, Judge.
thank you, sir. Have a safe trip. Where are you coming? Where'd you? Houston. Be safe getting back.
Thank you.
Yeah, and then did we lose Mr. Gertz also?
They went in the back, he's in the back.
They're pleading at the end of this team, and trying to find the code, because what I have is a pleading, they're saying it's a
Okay, that's fine. Take your time. And so we've got, I'm holding 2 for him, and then Burbanks, and then Buddy, where's Mr. Reynolds? And I held it, I think, for them to. Yeah, on Buddy's, on Mr. Reynolds, did y'all talk about? That was the Deshandra Joseph.
Gonna give me maybe until tomorrow. to
Oh,
make a
that's
phone
right.
call.
Yeah.
But we
Sorry.
did talk about it.
Yes,
So we're,
I wrote down the wrong thing. I wrote hold, but I meant to write till tomorrow. Okay, thank you. So reset Hatcher. Right, Gertz is. Yep. And then. Mr. Gertz, on Shay Morgan, were you able to visit about Miss Morgan's case?
Yeah, yes, Judge, I'm gonna ask for, she's sitting right.
Miss Morgan, Shay Morgan, come up, please, ma'am. All right, ma'am, you're Shay Morgan? And Miss Morgan's charged with theft of property and cause number 24 DCCR 2102. Mr.
Judge,
Gertz?
we have an offer for resolution in the case. Ms. Morgan has indicated initially that she wants to go to trial, but she's got a number of things that she wants me to look at in terms of evidence, and she wants me to present to the state prior to rejecting the very, I think, reasonable offer that the state is making, or the reasonable option that the
So
state is
here's the
giving us.
thing, Miss Morgan, I'm gonna address you on this. Mr. Gertz has been your attorney for over 6 months now. So if there's information that you think is important, you should have been getting that to him 5 months ago. So I'm gonna reset the case one more time. This is the last reset. So whatever information you need or get to him or think is important, get that to him so he can get it to Ms. Malfino. And at the next court date, if there's a resolution, great. If not, then we'll get it moved to the trial docket.
Okay, thank you,
Okay?
Judge.
All right, you're free to go. Ms. Hawkins and Ms. Malfino on Devin Spites. All right, so Mr. Spites tested positive for THC. And so obviously sometime within the last 30 days or so, he's used marijuana, because typically that's how long, which means that he used marijuana after he pled guilty on a felony. He pled to an enhanced second degree. I've got pages of criminal history here. And you would think, Mr. Spites, that based on what Ms. Hawkins is telling me about your family situation and your children, that you would be able to figure this out on your own and stay clean so that you didn't, number one, go to prison. I don't even have to accept this plea agreement. I mean, you've got 3 prior convictions, a state jail felony from 2019, from 2019, credit debit card abuse from 2021, and then an unlawful possession of a firearm in 22. None of those cases did you receive probation, which is probably why Ms. Malfino made that offer to try to get you on the right track. And Ms. Hawkins did a great job of getting you a probation offer on your case or cases.
If I may.
Yeah.
Part of the reasoning behind that offer that Ms. Hawkins and I discussed was that jurisdictional type issue that she addressed with the court, and also the fact that there ended up being no restitution that's owed to any individual.
Okay, and I appreciate that argument that Ms. Hawkins made, but it's also important, and I would hope that other judges in other counties would find it just as important, that if you're going to get charged, wherever you're going to get charged, that they take into consideration that just because you didn't steal from someone in our county, you stole from someone in some county, right? And so we got you here, but somebody's a victim. And it's important to me, and hopefully important to every judge in the state of Texas, that we kind of look out for each other in each other's counties. So I get that you were just traveling through, probably lucky that we got you, because who knows what would have happened at that point if you ever would have gotten caught. And that's not fair, no matter what county the crime is actually committed in. Does that make sense? Based on everything that is being offered to you and what the pre-sentence talks about with regard to drug usage, the only way I'm going to go forward with this is with some inpatient ISF up front. So it's not necessarily meant to be a punishment. It will probably feel like it a little bit, but if you're going to be successful in the rest of your life and be there for your children, then you got to figure out how to stay clean and make some better decisions. So that's what's going to happen today. Any reason not to go forward with sentencing at this point?
No, Your Honor. No, Your Honor.
Just my only concern with that is the other pending cases in Fort Bend and adjacent county. I don't know why it's simply taking.
What are the court, or do you represent them in Fort Bend?
Not
And
Fort Bend, Judge, no. I have his attorney's information up there.
what about the Harris County,
I do represent.
that abating?
I do represent him in Harris County.
I just don't, I'm trying to think of logistically, because I mean, one thing that I can do, I'm just not inclined to let Mr. Spites walk out today on a probation when he tests positive with this kind of history and with technically 4 felony cases pending in 3 different counties. So,
I have to ask Judge, my next question was gonna be, is there typically a report date that could be given for ISF and the attorneys
No.
on in for it?
Nope. And so what I'm going to do is I'm going to order it. And then once he's in custody, if you'll let obviously Harris County know that he is in custody. And if they will put a hold on him and come get him, I'll release the ISF hold while he goes and takes care of with that. Same thing with Fort Bend. But then if those are going to be probations or whatever happens, we'll put our hold back on once he's gone. So that when he finishes those counties, we've still got him for ISF. Sometimes what happens if that process takes a really lengthy time, then potentially if I feel like it's a good enough time, then I can hold that at abeyance at that point and require something like JCDI, which is outpatient. But based on the positive drug screen today and based on this criminal history and what all's pending, he's not walking out of here today. So we'll do it that way. If you'll get with his attorney in Fort Bend County, the sooner they get something set and get a hold on him, the better. Okay, that way he can get transferred, get those cases taken care of.
And I'll reach out to those DA offices, judges.
Perfect.
Maybe with the court's order, they would be willing to negotiate their
Something
cases.
quickly.
Yes.
So, Mr. Spites, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney, and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine. There is no restitution, and you're ordered to enter and successfully complete. Mr. Spites, talk to her in a minute. Just listen to what I'm saying, okay? You're ordered to enter and successfully complete the substance abuse track of the ISF program. And if you do all of this, this is a great opportunity for you. I know it doesn't feel like it today, but you have a great opportunity in this case, number one, without another felony conviction, and to be able to serve any sentence while you're out on probation. I want you to make sure you understand, though, what the consequences could be if you violate this probation. So if you choose to smoke marijuana again, or not show up for an appointments, or whatever it is, then you're looking at not just a sentence of the theft of property, which is the 3rd-degree felony. You pled to an enhancement, which means if you violate, you could be found guilty and sentenced to prison for anywhere between 2 years and up to 20 years. So I'm trying to keep that from happening and give you some tools so you can be successful. I'm handing you the trial court certification that shows this was an agreement. I followed it, and so you've waived your right to appeal. You can go back with the bailiff. Ms. Hawkins can visit with you back there, okay? Yes, sir?
Okay. The fact that, all right, y'all taking me in, that means like I can't get out from here. How can I get out so I can be able to handle Fort Bend?
We're gonna let them know that you're in custody, and they'll come transfer you over there from our custody.
Okay, so that's what I'm saying. That's what I'm trying to understand. Okay, if I'm on bond with them, like how would that work?
Ms. Hawkins can explain it to you, okay? All right, you can go back with the bailiff. Thank you, Ms. Hawkins and Ms. Morfino. Did you figure out Cracknell?
Because what I have is going to state jail and they're saying it's a class A.
What is it being reduced to?
So the solution of prostitution, it's a 2021 case. In the 2021 code, that's what's
Has the law changed?
I thought the law had changed to take it from an A to a state jail in like 22. Like the legislature changed it in 22.
So then, like the 2019, 2020 code would probably be
Yes,
the...
would be sufficient, yes. Sorry to be difficult.
That's okay, that's why I keep my old ones up here. Let me, do this. Okay, let's see, Mr. Gertz and I guess Ms. Malfino and Chad Cracknell.
I'm happy to talk about it. If it takes the risk off the table, I'm happy to talk about it.
Yes.
Yes.
Give me just a second to pull this up properly. All right, you're Chad Cracknell,
Yes, ma'am.
and Mr. Gertz, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Cracknell, you're charged in cause number 22-39948 with a second-degree felony. I'm sorry. The state has elected to proceed on the lesser offense of a Class A misdemeanor, solicitation of prostitution, under Section 43.02. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with?
Yes, ma'am.
And so I'm going to, just to make sure, based on our previous discussions, the charge is from 2021, and the law that would be in place at that time would be from the code, I guess, that we have dated 19 and 20, where there's been some changes in the level of the offenses of solicitation of prostitution, and the lesser included offense at that time of solicitation of prostitution, well, the offense of solicitation of prostitution at that time was a Class A misdemeanor, which is why that is what we are referring to and pleading to at this time, which is a lesser of the offense that he's been charged with, which is for a child under 15. Correct, everyone?
Under 18, but
Under
yes.
18, I'm sorry.
Yes, that's
Same.
correct.
Okay. And so, Mr. Cracknell, I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation, so you'd be on probation for 2 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State Tenors Number 1,
Judge, we have no objection.
it's admitted. Is there any evidence that Mr. Cracknell is not competent?
No, Judge, but can I put something on the record about
Sure,
that, please?
of course.
Mr. Cracknell's father is here with him. The court, a different court, has appointed him as his guardian, as Chad's guardian, in part because of some mental health limitations that he has. He's competent, he's lucid, he understands what I'm talking about. But I've also discussed all of this with his father, who's his guardian, and he understands everything that we've talked about. He understands what the offer is, he understands what the potential consequences are, and we thoroughly discussed it with Chad. He understands how serious this is. He understands that the court can put him in jail up to a year if he violates his probation. And one of the reasons we're doing this, and his father and I have agreed to this offer that we think is a very good offer from the state, is that for the last 4.5, 5 years that Chad's been out on bond, he's been doing everything that the court has ordered him to do. And so we feel confident in his ability to follow the court's rules on probation.
Could have had probation done and over with without all the legal wrangling. But anyway, thank you for that,
I've been
Mr.
asking for a
Gertz.
while, Judge. I've been asking for a while.
And thank you, sir, for being here. And just for the record, your name is?
John Cracknell.
And Mr. Cracknell, you've gone over all of this with Mr.
Yes.
Gertz, like he said, and with your said Chad, and understand and believe that he also understands everything that he's signing, understands what the consequences are with the probation, and if he violates it.
Yes.
Thank you, sir. All right. Then, is there any reason to get a pre-sentence report?
No, Judge.
All right, so Mr. Cracknell, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And if you successfully complete the probation, the case will actually be dismissed at the end. You'll never have this conviction. The other side of that, though, is if you violate any condition of probation, you don't follow the rules with probation, you can come back to court, I can find you guilty, and you could go to the county jail for up to 1 year. Do you understand?
Yes, ma'am.
All right, then, I'm going to hand you, oops, let me get that printed.
I've got it filled out.
They emailed me that.
Assuming that you, yeah,
I have it.
okay, thank you.
I'm going to hand you the trial court certification in just a minute that shows this was an agreement that I followed, so you waived any right to appeal. And then you'll just need to have a seat as soon as I hand that to you. You can have a seat here in the courtroom.
The judge then explained exactly what was going to happen. Spites would receive 5 years of deferred probation, a $500 fine, and no restitution. But there was a major condition. He had to enter and successfully complete the substance abuse track of the ISF program. The judge emphasized that this was not simply meant to punish him. It was supposed to give him a chance to change the situation, stay clean, and remain available for his children. Then came the warning that changed the entire tone of the hearing. The judge told Spites that violating probation could have devastating consequences. If he smoked marijuana again, missed an appointment, or violated another condition, the court could move forward with the underlying felony. Because the charge had been enhanced, the judge explained that a probation violation could expose him to a prison sentence ranging from 2 years up to 20 years. Spites was then taken into custody for the next steps, and he asked how he could handle his other pending cases. The judge explained that the other counties would be notified and could arrange to transfer him. The message from the judge was crystal clear. This was a second chance, but it came with strict conditions. One more serious violation could turn a probation opportunity into years behind bars.
Those counties, we'll just release our hold
Okay,
to let him get out of here, and then we'll put our hold back on him so that when he's finished with those, we can get him to ISF.
gotcha, okay.
Again, if that takes months and months and months,
Right.
then
That's my- that
we
was
can,
my
it could,
fear.
yeah. If it
The
does,
parents
get,
are crazy.
okay. Get with us if we're looking at least, I would say, if we start getting to 4 or 5 months, let me know, because that's more than the time that he would be spending in ISF, and I would consider that maybe as a sanction, and then get him out and get him in an intensive outpatient.
Okay,
But let's just see where we get from now.
thank you, Judge.
Okay, thanks. And did you and Mr. Ward talk about, Ms. Malfino, did you all talk about a bond condition on,
We did, Judge, and I didn't want to agree to the.
Okay.
removal of the drug
He's
test.
gonna
I
file
think we have
something.
the case worked out to plea. I think they reset it for plea like
Okay.
30 days.
okay, thanks. So it's just Mr. Burbank then, that we need back, I think?
And he is in front of Judge Davis.
Okay. McFarland. So, your name is Anthony McFarland?
Yes, ma'am.
And Mr. McFarland, it's very important that you're here on time.
Yes, ma'am.
Because what happens when you're not is I filed a bond forfeiture, and so you have a warrant for your arrest right now. I'm gonna recall that today, but it's important that you, are here
Yes, ma'am.
on time. Give me just a second to finish doing something on here, and then I'll pull your case up. I'm sorry. Take just a second. Let me find you. So, Mr. McFarland, this is your initial appearance in cause number 25, DCCR 1634. You're charged with tampering or fabricating physical evidence with intent to impair from April 6th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am. I had a court appointment.
Right.
But I talked to him before I got here. He was like, he was out of town.
This courtroom hearing took a serious turn when the judge confronted Devin Spites about a positive THC test and his criminal history. Spites had already pleaded guilty to a felony, and the court had been considering a probation deal that could give him an opportunity to avoid prison. But the judge learned that he had recently tested positive for marijuana. The judge pointed out that this meant he had used marijuana after pleading guilty, while already knowing that his future depended on following the rules. The situation became even more serious when the judge reviewed his record. Spites had multiple prior convictions, including a state jail felony, credit or debit card abuse, and unlawful possession of firearm. The judge explained that none of those earlier cases had resulted in probation. His attorney argued that Spites had 5 young children, and that keeping him in a strict inpatient program could make it harder for him to provide for them. But the judge wasn't convinced that simply allowing him to walk out on probation was the right decision. The judge made it clear. With a positive drug test, several prior convictions, and additional felony cases pending in other counties, Spites was not leaving the courtroom that day.